I want to talk in the last few minutes about Tarasoff and child abuse reporting. There haven't been even any substantial changes in Tarasoff standards since 2004. It's been about 9 years since the Ewing versus Goldstein case. And just as a refresher, and I've given some history here, but it's not, this is background. It's not anything that's changed substantially. In the Ewing versus Goldstein case, as you know, that case interpreted our statute for 43.92 of the Civil Code to say that when we talk about a patient communicating to a psychotherapist a serious threat of physical violence to an identifiable victim or victims, and that triggers our requirement to do two steps. The first is to make reasonable attempts to notify the intended victim or victims, and then second, do so with law enforcement as well. This case expanded the patient communication from the patient to the patient's immediate family, when the immediate family member gives that information to us for the purpose of advancing a patient's therapy. Okay? That's 9 years old. Kind of staggering to me that that case has been around for 9 years. That being said, it hasn't changed in any substantive way since that point. There have been some interesting small shifts, but nothing big. One of the small shifts that I think, it's one of the reasons I've gotten very concerned about the idea of professionals searching for client information on the internet. It's because of this case called Greenberg versus Superior Court. Greenberg involved an unfortunate young man, William Freund, who was diagnosed with Asperger's syndrome and also had some other mental health concerns. He'd been seeing a psychiatrist, and he went on, he was on an online support group for people with Asperger's, or autism spectrum disorders, as we call them now. And he had said online that he was going to buy a shotgun and kill some people. He didn't tell his psychiatrist about this. He actually did go and buy a shotgun, and he murdered 2 family members of his only friend who lived next door. Really horrible case. The family sued Dr. Greenberg, who was the psychiatrist. Ultimately, they lost because the patient never said to Dr. Greenberg that he was threatening anybody. He was disgruntled, but he never said anything. But one of the tricky parts that was brought up in this case was that there was this information on an online support group. And although the court and the lawyers didn't make the connection, I made the connection about, well, if professionals are regularly searching for their client information online, the next, or one next step may be, we have a duty to search for that information. And I want to discourage people from taking that duty on by just doing so through curiosity. For an emergency, yes. This case did not involve an emergency. Okay? So just be aware of that one piece. Again, not big, and it was my own, kind of paranoid fantasy about what could happen.
What's the second part about they let the case go on?
Oh, they went on to a public policy argument that heralded back to a 1959 case, but he still won. Dr. Greenberg still won the case because there was no information for him to base a Tarasoff on. He didn't get any warning. The other change that I want to have you be aware of is that in July of last year, so a little bit over a year now, a very small change happened in our statute for Tarasoff. And that change was the removal of the terms a duty to warn. Please don't make much of this. We have the same duties. We have the same duty that we did before to try to reasonably notify the intended victim or victims and police, but that's now being termed the duty to protect. And the reason, this was under Senate Bill 1134, the reason for these changes were some subtle difficulties that lawyers who were trying these cases were having with juries and jury instructions. Because juries were thinking, the way the statute was written, that there were 2 duties. There was a duty to protect and a duty to warn. So instead of a duty to protect and a duty to warn, there's just a duty to protect, and it's fulfilled in exactly the same way it's been fulfilled since this law was passed in 1985. Okay? So if you hear people making a big deal about this language change, be skeptical. It's not intended to change the substance of the law. Okay? And then the last thing that I wanted to talk about had to do with some child abuse reporting updates. The Penn State University debacle that took place over the past year or two has given rise to many states, including California, widening the group of professionals who are mandated child abuse reporters. So CANRA is the Child Abuse and Neglect Reporting Act in California. Last year, and that is last summer, statutes were changed, were passed, where all employees and administrators in post-secondary education are required to report abuse. So even if I wasn't a psychologist and licensed in California, the fact that I work in a post-secondary educational institution means that if I witnessed or heard about child abuse, I'd be a mandated reporter in California now. Okay? So professors who teach, occupational therapy, or professors who teach physics, or football coaches are all mandated reporters now. That's a pretty big shift. Another shift, which is AB 1435, is that in grades kindergarten through 12, athletic coaches, directors, and administrators have been added to the required reporter list. That's because many of those folks were volunteers. They weren't teachers. And so they were not mandated reporters. Now, if you sign on to do that role, you're a mandated reporter. In addition, a couple of other provisions were changed. One is that commercial computer technicians are now mandated reporters. And although professional and commercial print and photographic processors have been for years and years, they must report any representation of information, data, or images, because it's all digital now. So there was an issue about people saying, well, it's not really pornography because it's just digital data. Not so. So you see how there's an expansion here of who reports and under what conditions. And then there's a case that goes in the opposite direction, which I will end the afternoon and the day on. This is a really interesting case for those of you who do any kind of legal work. Elijah was a little boy, a 10-year-old, who had apparently committed arson, or at least that was the allegation. And the question was whether he was competent to stand trial as a minor. And the defense asked to have a clinician appointed to do an evaluation of this little boy. And the clinician, a psychologist, when she was contacted, a panel member, basically said the usual warnings that we all give people whenever they contract us for services. Here's my fees, here's what I do, blah, blah, blah. And if I have any reasonable suspicion of child abuse or neglect, if I have to do a tariff-off, elder dependent adult abuse, or neglect, or a court order, I will have to disclose the information. The defense attorney said, no, you're not. They went into court, and the judge agreed with the psychologist and said, yes, you do have to report these things. But this inventive attorney appealed it to the Second Circuit Court of Appeals, and the Court of Appeals agreed with the attorney. Now, if we are hired by attorneys or court appointed, this is relevant for what you do, attorney-client privilege trumps child abuse reporting. That's the current law in California. This makes me very nervous because we've had many, many years of California law being we are mandated reporters, we can be disciplined if we fail to report, we can be convicted of a misdemeanor, we can be sued under Landeros versus Flood. This doesn't look like it's going to go up to the Supreme Court, although I'm not sure at this point. It doesn't look like it's going to go. But if you do work for courts where you're court ordered, make sure you get a clear agreement or an order from the court that you're supposed to report. Or if the court orders you not to report, okay, but it makes me nervous because the law is quite different. And granted, this is a collision, a direct collision of attorney-client privilege, which is constitutionally based, and a legislative provision which is not constitutionally based. It may well be that our Supreme Court decides that, in fact, attorney-client privilege trumps child abuse reporting. But again, I'm nervous about going ahead and assuming that that's how our Supreme Court will go, or our legislature, or a particular trial court, or our boards, Board of Behavioral Sciences or Board of Psychology. So please exercise caution.